Supreme Court of India, Aniruddha Khanwalkar vs Sharmila Das and others. Decided on April 26, 2024. 2024 SCC Online SC 655. Facts of the case. The marriage of the appellant was solemnized with the respondent number 1 having come to know that on the date, she was already married and had not obtained divorce from her first husband. The appellant filed a petition under Section 11 of HMA Act before Family Court seeking annulment of marriage between the appellant and the respondent number 1. Subsequently, the appellant filed the complaint against the respondent numbers 1, 2, and 3 in which the magistrate issuance of process against the respondent number 1 for the offences punishable under sections 494 and 420 read with section 120b IPC, and against the respondent numbers 2 and 3 for the offence punishable under section 420 read with section 120b IPC. Session judge partly allowed the revision petition and set aside to the order of magistrate to the extent of taking cognizance of the offence punishable under section 420 of IPC against the respondent number 1 and for the offence punishable under section 420 read with section 120b of IPC against the respondent numbers 2 and 3. High Court was upheld. Findings of the court: the appellant and the respondent number 1 came in contact through a matrimonial site. The appellant was already divorced, whereas the respondent number 1 had uploaded her status as process of divorce is under consideration. The respondents had shown to the appellants an unclear photocopy of the decree of divorce which was believed to be true. On March 11, 2018, the appellant gave his consent for the marriage. Date was fixed as 28 April 2018. On June 16, 2018, on June 16, 2018, on account of some medical complication, the appellant as well as the respondent number 1 rushed to the clinic of a lady doctor in Shivpuri, Madhya Pradesh, where couple resided after their marriage. The doctor disclosed that the respondent number 1 was pregnant. It was nothing else but cheating by showing a fake decree of divorce. It was for this reason only that the respondent number 1 wanted to get the pregnancy aborted. The appellant felt cheated. The sessions judge failed to appreciate the fact that certain events had taken place thereafter, namely, apprising the appellant about the decree of divorce having been passed and showing the forged copy thereof to him on mobile. The learned Sessions Court has considered the revision against the summoning order as if after trial the findings of conviction or acquittal was to be recorded. It was a preliminary stage of summoning. For summoning of an accused, prima facie case is to be made out on the basis of allegations in the complaint and the pre-summoning evidence led by the complainant. Considering the material on record, in our opinion, the approach of the learned Sessions Court and the High Court in setting aside the summoning order against the accused persons, i.e. respondent numbers 1, 2, and 3 under section 420 read with section 120b IPC is not legally sustainable. Prima facie case was made out for issuing process against the respondents to face trial for the offence punishable under section 420 read with section 120b IPC, for which they were summoned. The appeal is accordingly allowed.